Hello, and thank you for being here. Today, we're going to explore a vital aspect of integrating AI into your business so that you understand the legal risks, client and customer rights, and the importance of disclosure. Before we get started, hi, I'm Michelle Wilson, and I am a licensed business attorney with over 12 years of experience. Currently, I serve as the managing attorney at Wilson Murphy Law. And over the years, I've had the pleasure of working with a diverse group of clients, including service providers, e-commerce brands, medical providers, freelancers, and online business owners. My main focus has been on helping them protect their businesses through trademarks, contracts, and self-guided legal solutions. Today, I'm excited to share my insights and knowledge with you as we delve into the fascinating and evolving world of AI in business. So on the agenda, we'll be discussing 4 things, and then we'll do a live demo at the end. So first, we're going to discuss the legal risks of using AI. Second, what your clients and customers have a right to know. Third, what a proper disclosure looks like. And 4, your AI disclaimer and what should go into it. And then we will do a live demo of building an AI disclaimer. So first, let's talk about the legal risks of using AI in your business. So one of the legal risks is privacy and data leaks. Public AI tools may store inputs like private client data and use them to train future models. And that's a potential GDPR violation and a liability for any business handling customer information. Second legal risk is ownership and copyright. So US copyright requires a human creator. Content generated entirely by AI may not be ownable. And there's also infringement risk if the AI reproduces someone else's protected material in that output. Another legal risk is deceptive marketing. So overhyped AI claims puts you in the FTC crosshairs. AI washing is a deceptive marketing practice where companies overstate, misrepresent, or completely fabricate their use of artificial intelligence. So using AI as a buzzword to artificially inflate your technological capabilities, attract investors, or mislead consumers is illegal. Another legal risk is the professional responsibility of it all. So you're legally on the hook for what your AI says or does. If a chatbot delivers wrong or harmful information to a customer, the liability lands on you, not the software company. That's true even if you didn't write a word of the response. And the last legal risk is contract and advice failure. AI-generated contracts can miss jurisdiction-specific requirements or critical industry clauses, leaving legal gaps in your agreement. Those issues usually only surface when something goes wrong, which is usually when it's too late and the worst time to discover them. So your clients and customers have a right to know about your AI use. Transparency isn't optional. It is increasingly becoming the law. So your client has the right to know when they're talking to a machine. Customers have a right to know if they're interacting with AI rather than a human. And this is a growing regulatory expectation across the EU, US, and beyond. Your client also has the right to know how decisions are made. And when I say client, I'm using client and customer interchangeably. So when AI drives high-stakes calls like loan approvals, insurance decisions, account restrictions, affected individuals often have a legal right to a plain language explanation of how and why that outcome is reached. And then if content is AI generated, audiences reasonably expect to know when an image, article, or video is produced using AI, especially when they're making purchasing or trust decisions based on it. Customers and clients also have the right to know how their data is used. So customers should know what data the AI is collecting, how it's stored, how long it's retained, and whether it's shared with or sold to third-party platforms before they hand it over. And lastly, they have the right to a human. There should always be an ability to speak with a real person or request human review of an AI-driven decision. Users should never feel trapped in an automated loop with no way out. So basically, if AI touches your customers or your clients, your business needs to disclose. Now, what is proper disclosure? First, let me define what disclosure actually means. And that's just telling people the truth about how you're using AI in your business in this case. Where it shows up, what it's doing, what it can't do. So when something goes wrong, I didn't know I had to disclose. That is not a defense. So here's what doing it right actually looks like. So first, you want to make it easy to find. Put your AI policy somewhere visible, like the footer. Link it and label it AI use policy. or have a notice pop up before users interact with any AI powered features. You don't just want to bury it in your terms of service or website terms of use. Those are used interchangeably. Next, you want to use plain language. A regular person should be able to read your disclosure and understand what the AI does and what it does not do. You want to be honest about flaws. AI does hallucinate, it misses context, and it reflects biased training data. A good disclosure says so and reminds users to independently verify anything important. And when you can, use context-specific labels. So match the label to the situation. For chatbot bots, say this chat is AI-powered. For content, you can say something like auto-generated by AI. For testimonials that you edit with AI, you can say lightly edited for grammar. All feedback is from humans. Now let's talk about the AI disclaimer, AI use policy, and what goes in it and why. So again, you want to make sure that your placement of your AI policy / disclaimer, I'm just going to use those interchangeably. So you want to place it prominently on your website, like in the footer. You'll want a link that is labeled AI use policy or AI disclaimer. So let's dive into the language of your disclaimer. It is important to note that AI generated content is provided as is, and that means that there are no guarantees or warranties, as AI can sometimes produce errors, outdated information, or omissions. And unlike human judgment, AI lacks the nuanced understanding that a qualified professional might provide. Human oversight is another critical component. You need to clearly disclose how your content is reviewed. Is every piece checked? Are reviews done when possible, or does it vary by content type? Choose one approach and communicate it honestly. Next, the limitation of liability should also clearly be stated. Your disclaimer should expressly disclaim all liability for any losses or damages arising from decisions based on AI-generated content. And lastly, if you are a professional, especially, it's essential to underline that AI content is not a substitute for professional advice, whether it's legal, financial, medical, or another area. Users should always consult with a qualified professional before making any decisions. So when crafting your AI disclaimer, it's crucial to address AI's limitations. AI outputs can sometimes be outdated, biased, or incorrect, reflecting the biases in their training data or even overlapping with copyrighted material. So this makes it important to clarify that AI content is not guaranteed to be fully original, and using AI outputs doesn't transfer any ownership rights to users. Equally important is the user's role. Users must independently verify information, especially if it impacts business, legal, financial, or health decisions. Additionally, consider adding clauses that align with your business operations. So for digital products, disclose AI assistance inside the product or on your sales page. For client deliverables, note AI use in your contracts. For educational content, if you have AI supported programs or courses, disclose within the course platform or member area. If you have AI edited testimonials, you should acknowledge the AI's role while affirming authenticity. If AI is used solely for internal operations, specify that to limit exposure. And if you are using AI personalization, so like recommendation engines or dynamic content, you should also add that to your disclaimer. So these elements ensure transparency and help manage expectations. Next, we are going to build an AI disclaimer. And we are going to use a tool called Covered, and it is a contract generator that I built. And so we're going to walk through how the contract generator takes your inputs and produces a complete, ready-to-use AI disclaimer tailored to your specific business. I will show you how the generated document maps directly back to what we discussed in the previous section so that you can see theory become a usable document. And then I will highlight the customization that you can do with the generator. So like you can choose which AI tools to list, which human review option is accurate for your practice, and which add-on clauses apply to your specific offer suite. All right, so here is Covered, and you'll see all of the different types of contracts that you can create. So we're going to go into disclaimers and add-ons, and here's the AI use disclaimer. So let's put in some information. So for my business information, I'll do my law firm, Wilson Murphy Law, PLLC. My website URL is www.wilsonmurphylaw.com. Contact email is info@wilsonmurphylaw.com. Where this disclaimer lives. So where is this disclaimer going to be published? Is it going to be on your website page, in your client contact, welcome guide, onboarding, materials, or all of the above? Mine will be my website page. And then what AI tools do you use? So I will list out what I use. So I use Claude. Oops. I use ChatGPT. I use Perplexity. I use Canva. And I use a tool called TTPO for my trademark searches. Okay. So then drafting. So how do you use the AI? And so you have all of these different options. So drafting written content, yes. Editing and proofreading, yes. Research and information gathering, yes. AI-generated images, no. Client-facing deliverables, yes. Brainstorm ideas, outlines of content strategy, yes. Social media and captions and hashtags and stuff, yes. Email marketing content, yes. Course curriculum or educational content development, I'll say yes. Templates, frameworks, or document drafts, yes. Transcription or summarization of audio and video, yes. SEO optimization, sure, yes. Chatbots, automated responses, or client communication tools, yes. Internal operations only. Planning, scheduling, admin, not really. And any other AI use for me, I'll say trademark services. But that would probably be under research, but it's fine. And then human oversight. So are you reviewing the AI output? So for me, all AI output is reviewed and edited by a human. But you can also choose it's spot checked. It varies by content type, or AI is only used internally. So, and then deliverables are human created. Can clients opt out of AI use? In my case, no. But in certain situations, they can. But I'll just say no. And then limitations to disclose. So we have all of these options. So AI might produce inaccurate, incomplete, or outdated information. Yes, I absolutely want to disclose this. AI output does not constitute legal advice. Absolutely. AI cannot verify facts or sources in real time. Disclose that. AI output may reflect biases. Yes. AI results may vary between uses. Yes. AI may not reflect current laws, regulations, or platform policies. Sure. AI-assisted content is not a substitute for personalized professional judgment. Absolutely. And third-party AI platforms may retain or process input data per their own privacy policies. I would disclose that. And then if you have certain things that you're using in your business, like certain operations that you have, you can add all these clauses. So AI in digital products, AI in client deliverables, AI for internal operations, AI in educational content, AI editing of testimonials, AI-driven personalization. So for me, I only have it for the law firm for these two things, and then we will generate the contract. And this is what your output looks like. And so we see that we have the section, how we use AI. Like we said before, no guarantees or warranties. That's something that we discussed in the AI disclaimer section. We have that human oversight. We have that limitation of liability, making sure that we make it clear that it's no professional advice, the AI limitations, intellectual property and authorship, user responsibility, AI use in deliverables, and AI use for a total operation, and then who we can contact. So all you would do, you would copy and paste this, and you can put it in like a Google Doc, and if you need to make slight changes, you can, but overall you'll want to keep this structure of how it is. And that is how you would use this contract generator to create your own AI disclaimer. The key takeaways from this is that the legal risks of AI are privacy exposure, copyright issues, and FTC liability. Your transparency is a competitive advantage, not a burden. Customers trust businesses that tell the truth about their tools. And a proper AI disclaimer is one document that covers most of your disclosure obligations. If you have any questions, you can go to wilsonmurphylaw.com and get in contact with me, or email me at info@wilsonmurphylaw.com. And if you want to see me in your inbox monthly, you can sign up for the Mark. It is my monthly newsletter where we discuss IP strategy, cases, and moves for business owners who want to protect what they're building straight from an intellectual property attorney. And I forgot to mention that if you just wanted the AI disclaimer template on its own, you can grab it when you grab the freebie. It is an order bump. Thank you so much for being here, and I hope you learned a lot.